You're listening to Economics Detective Radio. My guest today is David Friedman of Santa Clara University. David, welcome to Economics Detective Radio.
Glad to be here.
So our topic for today is David's book. It's called Legal Systems Very Different from Ours, and it details a number of different legal systems from different times and places in history, and how their details are, as the title says, very different from ours. So, David, I want to start with Iceland. I understand from...
Let me start by pointing out this is a book that has not yet been published. I have a couple of publishers interested, but at the moment what you have read is a draft of the book that's up on my webpage for comments.
Right. So the publication, I hope it's coming soon. I've seen different versions of this draft. You know, you've been working on it for a while now, I understand, but it seems like it's fairly close to complete now. So good time to discuss it. My understanding from the introduction to the book is that you got started on this topic looking at Iceland, so I figured that would be a good starting point for our conversation as well. So what is so interesting about the medieval Icelandic legal system?
Well, there are a number of interesting things about it. I originally thought about it as a system where you had, in effect, tort law substituting for criminal law. My original interest came out of an exchange between some very prominent economists and some very prominent law and econ people at Chicago quite a long time ago, where the economists, Gary Becker and George Stigler, had suggested the idea of replacing our present model of criminal law in which the policeman is an employee on a salary with a system where if you brought in the evidence that convicted somebody, you got the fine he paid. And it hadn't occurred to them, I think, when they originally made that suggestion, they were really reinventing tort law. Because after all, in tort law, when somebody wrongs you, it's up to you to sue him, demonstrate that he did it, and then you collect the damages. And Richard Posner and Bill Landis wrote a response to that article in which they pointed that out and raised a bunch of interesting questions. And I ended up writing two different articles, one of which was a theoretical article on the economics of the system, but one of which was an empirical article pointing out that Iceland had in fact had the kind of system they described 1,000 years earlier, a system where if you killed somebody, his relatives sued you. And as became clear when I tried to study that system, that was only part of what made it interesting. The other half was that enforcement was entirely private, that they had a legislature, they had a law code, they had a system of courts, but there was no executive arm of government, so that all enforcement, basically, you got your verdict, it was up to you to enforce it. And yet it worked. This is a system that functioned for about a third of a millennium, longer than our system has functioned. It eventually broke down, but our system, after all, broke down into a violent civil war, less than 80 years after it was established. The Icelandic system went into a sort of a slow motion civil war starting perhaps 250 years after it was established. It was also an interesting society for unrelated reasons. We get the word saga from the Icelanders, and the Icelandic sagas are a set of essentially histories and historical novels that were written down in the 13th and 14th century, mostly set in the 10th and 11th century. We aren't sure if they were in oral literature that got written down later or were composed later, but they are sufficiently good so that there are probably a dozen of them currently in print in English translation. And this is out of a population of maybe 50 or 60,000 people at a far corner of the world 700 years ago. So it's quite an impressive society in terms of literary output per capita, in addition to a fascinating legal system. And these are connected because a lot of the information you can get on the legal system comes by reading the sagas, by getting more or less firsthand descriptions of how that system works.
I'm interested in where the system came from. Presumably, explorers from Scandinavia, Norway, Denmark, when they landed in Iceland, they had some existing legal system back home, but their new situation, they were very isolated, they had a much smaller population. Why did they have to adapt?
That isn't the reason for the change. What happens is that in the 9th century, Norway starts out as a patchwork of very small kingdoms with relatively weak kings. A ambitious ruler of one of those kingdoms decides to put the whole thing together into a kingdom and establishes a much stronger kingdom with much more authority over the individuals. And a lot of people didn't like it. At least that's what the Icelanders' account of their origins. The Icelanders' main professions at the time were farming and piracy. Lots of them were Vikings. So the ones who didn't like the changes that Harald Harfager had imposed on where they were living, loaded up their ships with as many people, with all of the people and as many of the farm animals and the gear as they could manage, and set off for Iceland, which had been discovered a few years earlier. So that's at least the Icelandic account of the settlement. And not surprising under the circumstances, they decided that they would base their legal system on the Norwegian legal system, but the one element of the Norwegian system they would leave out was the king. So you end up with a system where there is no executive arm of government.
Right, and so they had to replace the central authority of the king with a more decentralized authority. How exactly did that work? Who exactly got the final word on your lawsuit against the person who killed your brother?
What happens is that there is a system of courts and a fairly elaborate legal system. Most cases, in fact, settle out of court. There have been a number of scholars who've tried to estimate it, and it looks like something like 90% of the cases were settled out of court by private agreement, like an out-of-court settlement in our tort law. Or plea bargain, I suppose, would be the criminal equivalent. So if it goes to court, there is a procedure you go through, which involves what they would call judges, but we would probably call a jury because it was a bunch of them. It eventually gives a verdict. If you don't go along with the verdict, if you don't do what the verdict says, you get outlawed. The court declares you an outlaw. It is now legal to kill you, and it is illegal to defend you. So if your friends defend you and there's a clash and some people get hurt on each side, the relatives of the people who are the good guys, the ones who are acting with the law, get to sue the people on the other side for any injuries. And then if they don't pay those damages, the coalition expands against them. So it's a fairly stable system most of the time.
Okay, so there's a sense then that once you're an outlaw, you're on your own. And if you get people to join you, then no matter what, or maybe not no matter what, but there's going to be a larger coalition of people enforcing the law in general than there is defending you. And so you don't really have an option to just ignore the legal punishment against you.
There are a couple of cases of people who survive as outlaws for many years, but they're doing it mostly on their own with maybe a couple of friends hiding them or something. And we aren't sure if those are true or if they're just good stories. But normally, if you're outlawed, you either try to get out of Iceland or you end up getting killed. But usually, of course, you don't get outlawed because usually you bargain before the case is filed, but at least before the case is over, you reach an agreement to pay damages. And now the case is over. So the outlawing is sort of the final sanction in that system. But one of the things that's quite striking, if you read the literature, is that even when things are going quite badly, people assume that if you kill someone, you're eventually going to have to pay for him. And it's quite expensive. So that there's one case in Njál Saga, which would be set around roughly 1000 AD, where it looks as though it's going to break down into fighting in the middle of the open-air courtroom. And somebody on one side is talking to a sort of benevolent neutral, someone who's friendly but not actually involved, and says, if it comes to fighting, what'll you do? And he says, tell you what, I'll draw up my people armed over there. And if you're losing, you can retreat behind them, and that'll break up the fight. And if you're winning, we'll come in and break up the fight before you kill more people than you can afford. So the implication there is that even if things appear to be breaking down, eventually when the dust is cleared, if you kill someone, you're going to have to pay for it. And it's sort of striking that even if you look at the final period of breakdown, the so-called Sturlung period, that where you have what's virtually a civil war, nonetheless, if one side wins a battle, They will kill a couple of people they really care about killing and let everybody else go. And not uncommonly, each time sort of things quiet down, people pay off for people they've killed. There's one scene where the people who had been the attackers earlier refused to pay weregeld for someone they killed because they said, we offered to let him go. We offered to pay him to come out of that house before we attacked it, and he wouldn't, so we don't owe you anything for it. So again, you can see a system which really was pretty stable even when it was in the process of collapsing at the end. But I should say, one of the chapters in the book we're discussing is on what I call feud law, which is a general category of legal systems, which the Icelandic is the first one that I've seen. And as a sort of partial survival of it, in Islamic law, the essentially killing or injuring somebody is treated as a tort, not a crime. Now, in Islamic law, there is a court which enforces the verdict. It's not a semi-stateless system. But nonetheless, the normal outcome if you kill somebody is that his relatives take you to court. If the court rules that it's the equivalent of first-degree murder, they get to retaliate to kill you. But they don't have to. They can accept a money payment instead. And if it's the equivalent of second-degree murder, they don't get to retaliate, but they do get a money payment. And in modern-day Saudi Arabia, the money payment is something like $150,000. So it's not a trivial sum. I should say this book came out of a seminar I taught at Santa Clara University sort of every other year for a long time. And the very last time I taught it, I've just retired, my students mostly consisted of Saudi LLM students. So I had, as it were, primary sources in the classroom, because Saudi law, one of the legal systems I discussed in the book is Islamic law. Another one is Jewish law. They're both interesting legal systems. Neither of them is stateless in the sense that Icelandic is, but they're interesting. And here I had people from a society which had about as close as anybody's still got to real Islamic law, sitting there in the classroom to ask questions to. So that was a lot of fun. But I also look at a number of other such societies that I think of as feud law. And as I see it, the basic logic of feud law is that if you wrong me, I threaten to injure you unless you compensate me. And there are a number of conditions that has to meet in order to be a working system. The first condition is what I think of as right makes might. You need some reason why I am more able to harm you in retaliation if you really did wrong me than if you didn't. So it's not just extortion. So in the Icelandic system, the reason that right makes might is if you really wrong me, I can win my law case. You know I can win my law case. You know if I win my law case, I then have the advantage that now you end up as an outlaw if you don't pay. Therefore, my threat to attack you, to injure you, is believable, and so you give in. And other systems do it in other ways. One of the still existing feud systems that I discuss is the system in the Romagna, the largest English gypsy group. And that's an informal system. That is to say, formally speaking, of course, they're under English law. But a lot of the Romagna groups in various countries have been pretty good at staying below the radar, as it were, of the official legal system and then enforcing their own rules on themselves. And the Romagna system is what I like to describe as a primitive version of the Icelandic system of 1,000 years earlier. So that if you have wronged me, I threaten to beat you up. Both of us know that if you really did wrong me according to the norms of our society, my friends will back me and your friends won't back you. So that's sort of the very simplest version of a feud system. And therefore, if you did wrong me, you either pay up, or you leave town. But I've discussed a number of other systems that all work on basically similar logic, and they all have some way of giving an advantage to somebody who's on the right, some way of getting other people. So I'm not just a judge in my own case, whether it's the Icelandic law courts, which are a sort of formally set up system. In northern Somalia, Somaliland, there are procedures for setting up an ad hoc court that people respect. In the Romagna case, it's just a matter of a small community where whether other people will support you depends on whether they think you're in the right, and so forth for other systems. But there are several other conditions you have to meet. You have to have some way of making your threat believable. a commitment strategy so that when the other guy says, if you try to harm me, I'll harm you. You need some way of protecting weak people, some mechanism so that if you don't have much ability to beat people up, you still get your rights protected. And you need some way in which if you end up with a back and forth violence, you can terminate it. And I discussed in the chapter in the book the ways in which the various societies I've looked at have achieved all of those objectives.
Interesting. So, yeah, I think people's main fear with any kind of decentralized system is might will make right. And so a big theme in your book then is how do societies reverse that? How do they make it so that right makes might?
That's not quite right. You're focusing on what is particularly interesting to you, namely the stateless or semi-stateless systems with feud law. But that's only a small part of the book.
Yes. Okay.
The book isn't about that. The basic idea of the book is that all human societies face about the same problems. They solve them in an interesting variety of different ways, and they're all grown-ups. And therefore, you should take all of those seriously as possible ways of running a legal system and just try to understand them. The book is not a book about libertarianism or about anarchy or about stateless legal systems. It's a book about legal systems very different from ours, and some of the ones involved have this characteristic of privately enforced law with mechanisms such that right makes might. But I also look, for example, at legal systems where God is the legislator and how a legal system works when the people believe that their law is divinely inspired. So that would describe Jewish law, Islamic law, and I argue that in a sense it describes American constitutional law, that even though we don't call it divine, it has a lot of the same characteristics of a set of rules which are very hard to change, but which you can interpret around. I like to claim that by the standards of the rabbis, every Supreme Court justice in history was a strict constructionist. If you look at how far they went in interpreting around the actual text of the Torah. And I think you can see a similar pattern, somewhat less extreme in Islamic law and probably in other systems. So I'm looking at a lot of different things. I don't want to make it sound as though this is a book specifically about feud law. That's just one of the multiple subjects I covered.
Yeah. Another thing that I think it's great that you do in this book is you resist our tendency towards a sort of Whig theory of history, the assumption that things just march towards ever better outcomes, better systems. And you have a lot of praise for systems that are, very far back in the past. And, sometimes a good system could show up and then disappear. And we have things to learn from every period of history, which I love that approach.
That's right. They're part of the fun, sort of. I like to say part of the Icelandic solution to how you protect weak people is that tort claims were transferable. So if somebody has killed my son and therefore in principle owes me 200 ounces of silver as weregeld, but I'm an elderly man with no other sons, I don't have the ability to actually enforce it. If I try to go to court, I'll get beaten up on the way. I can transfer my claim to my neighbor who's got 4 tough sons who went Viking in their youth and lots of friends and relatives. He collects the claim. Maybe he splits the money with me. Maybe he doesn't, depending on how hard it was to collect it. But the result is that the person who killed my son ends up paying a whopping big fine or else getting killed. And therefore, even though I don't have power, I get protected. And I've argued that the idea of transferable tort claims would make a lot of sense in our legal system, that if somebody dents your car in our system, you may not know who a good lawyer is. You may not be able to afford a lawyer. You could maybe find a law firm that will take it on a contingency basis, but you don't know which one will do the best job. Whereas if we had the Icelandic system, you could simply auction off your claim to the highest bidder. The highest bidder would be the firm that was most likely to collect damages, because that's why they'd be willing to bid more. So I like to say that in that respect, American law is a mere 1,000 years behind the cutting edge of legal technology. And there are other examples, but that's sort of one of my favorite ones, where you've got a clever idea in a very old legal system.
Yeah. One of the other themes in your book is the idea of an embedded or polylegal system. So, for example, You've mentioned Jewish law. There was a Jewish state before the Roman conquest in 63 BC, and there has been since the foundation of Israel in the mid-20th century, 2,000 years later. One might naively think that without a Jewish state, you couldn't have Jewish law, but as you show, Jewish law continued to exist for that 2,000-year period without a Jewish state to enforce it. So how did Jewish law function?
And of course, the state of Israel does not run under Jewish law. The state of Israel uses Jewish law for some things, for marriage, I think. But in general, it's really a modern legal system. But no, what's happening with Jewish law during the diaspora basically after the destruction of Israel as a functioning system, is that the Christian and Muslim rulers found that the easiest way of dealing with their Jewish subjects was to subcontract the job of ruling them, so that the king or duke or whoever it was, or maybe a emir or a sultan, would agree with the Jewish communal authorities that they could enforce their rules on their people. They could arrange to pay him an adequate amount of taxes, which is what he mostly wants, and make sure that their people aren't a problem for him. And the result is that you have, for most of 2,000 years, most Jews are living under Jewish law, even though there's no Jewish state. And it's an interesting system for that reason. It's also interesting because for much of that time, there is really no equivalent of a Supreme Court. So you have a fairly uniform legal system maintained entirely by sort of reputational mechanisms, by saying, all right, we've got a hard case. Who's the best scholar alive at the moment? Let's send him a description of the case and we'll accept his opinion on what the proper verdict is. The other thing about Jewish law, I should say, is that it may be the best documented legal system in the history of the world. They are talking about a legal system for which you've got a very thick law book from nearly 2,000 years ago, and you've got proliferating thereafter a whole lot of documentation. You've probably got a couple of 100,000 of the equivalent of cases. These are the responsa, the messages that people somewhere in the diaspora sent to some prominent legal scholar and got a reply. So the result is that there's an enormous amount of information. It could be a lifetime. Sure, it is a lifetime study for some people, which I haven't done, but still quite an interesting system. So yes, in general, I distinguish between embedded systems and polylegal systems. That an embedded system is one like Jewish law, where you have some legal system and then a group within it who are running their own rules. And Jewish law during the diaspora would be one example. The Amish at present would be an example in America. I mentioned the case of the Romagna in England. Most of the Romani populations actually have embedded legal systems in that they are formally under the official legal system, and to some extent they're controlled by it, but to a large extent they're really enforcing their own rules on their own people. So those are all examples really of embedded legal systems. And I should say there's one chapter which I may or may not end up having because someone else is supposed to write it, and that's a chapter about college law. And that's the embedded legal system. There is a system of norms among American college students. That I came across somebody who'd been studying that, and he was supposed to have gotten me a chapter quite a while ago, so I don't know if he'll ever actually produce that chapter. I should say, in the book as it now is, 2 of the chapters are written by other people. There were 2 people I knew about who had done very interesting work. One of them on 18th century pirates, and one of them on prison gangs. And I considered just writing my own chapter based on their work, but I thought it made more sense to ask them if they'd write it. And so the result is that there's a chapter by Peter Leeson on 18th century pirates and a chapter by David Scarbeck on American prison gangs. And they're, I think, both quite interesting. And hopefully there's going to be one more chapter on college law if the person who's supposed to write that ever comes through with it.
Peter Leeson is a previous guest of this show, so if you to
listen. But I should say that that's not the same thing as polylegal. That a polylegal system is a single society where you've got multiple legal systems in the sort of, I mean, they're related, but in the Jewish legal system was really sort of one sitting inside another. Whereas if you think about Sunni law, for example, in Sunni Islam, there are 4 mutually orthodox schools of law. Madhab is the Arabic term for that. which I'm sure I'm pronouncing wrong because I don't unfortunately speak Arabic. And in the Middle Ages, in a major city, you would have courts for all 4 schools of law. You would also probably have a court for the Christians and a court for the Jews. You would probably also have a court for Shia Muslims, assuming there were some Shia Muslims in that city. So in effect, there isn't really a single law code. There's really multiple law codes. Most cases are within a community where all of the people are subscribing to the same law code, like Jews interacting with Jews or Christians with Christians, and then there will be some rule for determining what happens when you've got a cross case between such. And to some extent, modern American law is polylegal because we've got state law, and you may say, well, it depends what state you're in, but a legal dispute doesn't always have a geographical location. You can imagine a case where you've got an accident involving a car made in Michigan belonging to somebody in Texas, which gets into an accident in California. So there's a whole body of law which deals with how you decide whose law applies in those cases. So in any case, polylegal systems I really see as maybe they're a general, anyway, they're not the same thing as embedded. And generally the polylegal systems are legal. That is most of the embedded legal systems. The Jewish law is legal in the sense that the authorities approved of it. And I guess, Amish, basically the Amish just don't do anything that would be illegal, since their ultimate sanction for enforcing their rule is the threat of shunning, which is legal to do. The Romani generally have no legal status for what they're doing, but they manage to do it anyway. So these are all interesting things. I mean, a lot of this was just the fun of trying to make sense of how a bunch of different societies ran themselves. And I hope at least that a reasonable number of people will read the book just for the fun of it, aside from scholars who want to learn something, because it's interesting stuff.
Yeah, and there's a lot I could say about that. There's some interesting more examples of polylegal systems. What maritime law? What if 2 ships from different countries collide in the middle of the ocean? There's you mentioned the United States has a polylegal system. The exception would be in Washington, D.C., which, of course, does not have a state-level government and just has the federal government, and, of course, is one of the more dangerous places in the United States. So if, a little bit of de facto evidence that polylegal systems maybe help. And of course, there's Somali law, which maybe we could talk a little bit about, where there are the different tribes, different elders, and people have some choice over who enforces their rules. Tell me about that.
Well, sure. This is really Somaliland, which is northern Somalia, and Somaliland had an existing feud system, a stateless system, which had existed for a long time. I don't think we know for how long. In 1960, I believe, England had theoretically been in charge of northern Somalia and Italy of southern Somalia, although in the English case, they mostly left things alone with a little bit of intervention. And in 1960, if I remember correctly, England and Italy pulled out and established a centralized democratic government for Somalia, a country that had never had anything of the sort. And it lasted for a few years. There was a military coup. It then became a rather unpleasant military dictatorship. The military dictatorship got into a war with Ethiopia, which is more or less the traditional enemy of the Somalis. The Soviet Union, which had initially been backing the Somalis, switched sides. The war went badly. The dictator got killed. Things slid back, looked as though they were sliding back to the traditional system, and the U.S. and the UN decided that Somalia had to have a government. And we've been trying to impose a centralized government on Somalia ever since, doing it mostly with the assistance of the Ethiopian army, which is a great way of making yourself popular, sort of as if somebody decided the French needed a government, used the German army to impose it. So people talk about the chaos of Somalia, but the chaos of Somalia is almost entirely our fault. It had a functioning system with a certain amount of violence, as almost all systems have, but the mess at the moment is due to our intervention. In the north, there is what calls itself the Republic of Somaliland, which is more or less a sort of a semi-government largely based on traditional institutions, but we refuse to recognize it because that would be admitting there was no such thing as the country of Somalia, and we insist there has to be a country of Somalia. So going back a bit, when I got interested in Somalia, the first thing I read on it was a book written by a Dutch lawyer who spent, I think, the last 12 years of his life living in Somalia. And it was interesting, but the problem was that he was a libertarian. And I don't really trust people who agree with me because I'm too willing to believe them whether or not they're right. So I went looking for another source in a library. And it turned out that there was a British anthropologist, a retired London School of Economics, LSE anthropologist, who was the authority on northern Somalia. He had been studying it since the 1950s. When I went looking for books, I think the first 2 or 3 books I found were by him, and the next book was a festschrift written in his honor by other people about Somalia. So I got a picture from him, and it's a fascinating system because there are clans, but the clans aren't really all that important. What's mostly going on is a system of nested coalitions that, as Lewis, the anthropologist, put it, this is a case where you actually have a contract theory of government, only it's not exactly government, that you have a group of people who are related by some mixture of kinship and contract, who have agreed that if any of them is wronged, the others will help him to collect the damage payment he's owed. If any of them ends up owing a damage, the others will help him pay that damage, that damage payment. So that it's sort of a pre-existing coalition, often with an explicit contract in which they agree not just who are the members, but here are the rules. This is how much each person or each subgroup will owe of it, and so forth. And these coalitions are nested in that the coalition of, say, 100 people is also part of a larger coalition of maybe 300 or 400, which is part of a larger, and so forth and so on. So if you end up with a conflict where the other side is much stronger, you slide up to the next larger coalition that you're a part of, and that gets even odds. So it's quite an interesting system. It's, again, a feud system in that it's private action without a government. They've got traditional mechanisms for settling disputes involving courts, not a standing set of courts, but rules for how you bring up a court using some of the respected people of your community and so forth. So that's quite an interesting system as well. And not sure what else I could say about it. One of the bits I thought was rather neat as an economist was that there was one point where in the traditional system where the level of violence got higher than the people liked. And so the clans, members of whom were fighting each other, agreed between themselves to raise the price for killing somebody. They raised what the anthropologists call dia, which is actually the Arabic term, but what the Icelanders would call weergeld, the man gold, the price for a killing. And if you make killing people more expensive, you do lessen it, just like anything else, which as an economist I thought was rather elegant.
Yeah. So to add some extra details to that, I believe the anthropologists, there's a type of system like that called a segmentary lineage society. And there's a Bedouin saying that's me against my brother and me against our cousin, my brother, me, and my cousin against the world. And that's sort of illustrating that system. It's partly true. But in the Somali case, it doesn't have to be kinship. That in the Somali case, the presumption is that your coalition will tend to be, let us say, descendants of the same grandfather in the male line or the same great-grandfather. And every Somali knows his genealogy up many, many levels because that determines who's likely to be his ally. But you can, in fact, have coalitions of this sort that are entirely by contract. And it turns out that the Somali term for a coalition which is built without kinship, just built entirely by contract, is a pile of shields. And that was the Somali term for the U.S. coalition against the Soviets. That what we had from their standpoint was a pile of shields because, we and the Japanese weren't relatives, and yet we were allied against a common enemy. So in that case, it's a partly kinship, but not an entirely kinship system, and it's a system with explicit agreements about who's involved. But the interesting thing is, if you have these different levels of coalition, and if you have a conflict with someone within one coalition, then you have to go down to a smaller coalition to settle that dispute.
Correct. That is to say, I would have put it the other way around, but yeah, that is that the relatively lower level is where the initial things start, and you only go to the higher level if you need it for the numbers. And the sizes of the coalitions, again, it's sort of interesting from an economist standpoint. The more people in your coalition, the better able you are to win a fight. But on the other hand, the more people in the coalition, the more likely it is that there will be conflicts over leadership, that some of the subgroups within the coalition will think they're getting a raw deal. They'll think so that some of the other subgroups are having too many fights and they've got to pay for them and so forth. So there's a sort of a economy of scale, diseconomy of scale effect in these coalitions. Yeah, I.M. Lewis, by the way, is the anthropologist. He's unfortunately no longer alive. He was alive when I was originally working on this, and I actually corresponded with him by email. I had asked him a bunch of questions, and he said the answer to these questions is in the following book of mine. So I found that book, and it had the answer to the questions. I should say, by the way, that part of this whole project, part of the problem with it, was that I couldn't possibly know enough to really do it right, because becoming fully competent in understanding Jewish law or Islamic law or almost any of these systems is sort of I won't say quite a lifetime project, but quite a large project. So what I tried to do was to learn as much as I could, and then wherever I could to find somebody who actually was an expert, get him to tell me what I had wrong. And I suppose the most successful one of that was my discussion of 18th century English law, where I was able to find probably the leading scholar in the field. I read like 3 or 4 of his books, and he went over my chapter and told me what he thought I had wrong or didn't have wrong. But I tried to do that with varying levels of success with a fair number of chapters to find. I tried it with all of them, I think, and succeeded with probably most of them in finding somebody who knew more about it than I did, who would tell me where he thought I had things wrong. I should say that my original piece on Iceland was a article in, I think, the Journal of Legal Studies, which must have been something like 40 years ago. And the chapter on Iceland in this book not only has a lot more information, it also corrects some mistakes that I made there, because I was not expert enough. And in particular, I don't read Old Norse, which is the language that the Icelandic stuff is written in. So I was dependent on things that had been translated, and there was some material which hadn't been translated then and has been translated now, which I was able to add to the chapter.
Yeah, so there's no one who is qualified to be a lawyer or a judge in all of the systems you discuss, but
Correct.
We can...
Or even a really good scholar of all of those systems, that being a competent scholar of Islamic law is, again, sort of a lifetime profession. True of Jewish law, probably true of English common law, though I'm actually looking not at common law in general. In fact, the longest chapter in the book, I think, is on 18th century English criminal law. And what is interesting about that was that was criminal law that was privately prosecuted. So that in England until well into the 19th century, you have no police and no public prosecutors. I exaggerate slightly. If you actually commit a crime against the government, like counterfeiting money, then there's a government prosecutor. But if all you do is kill somebody or rob somebody, there's no government prosecutor and no government police who have the job of dealing with it. It's basically up to the victim or anybody else who wants to figure out who did it and prosecute him. And that I had also done an article with a long time ago. In a sense, part of the reason I ended up writing this book was that I had written the article on Icelandic on Saga period Iceland. It was a lot of fun, and I thought I learned a lot of interesting stuff doing it. And then I was lazy for quite a while. And then I got interested in 18th century English criminal law. And I actually got interested in it for a different reason, but then discovered what was interesting about it was that it was privately enforced, privately prosecuted, not enforced. And I learned a bunch of interesting stuff there. And then I was lazy for a long time again. And I decided that I really was making a mistake, that these projects have been very profitable, intellectually speaking, and I should do some more of them. And I needed a commitment mechanism. I needed a way of making myself do some work that I thought I ought to do. So I announced that I was teaching a seminar the next year on legal systems very different from ours. And that meant I had to acquire enough information for a semester worth of a class. I went to the people at the Santa Clara University Library, who were nice, helpful people. And I said, find me every book you can on an odd legal system. And they provided me with one of these little rolling bookcases with about 3 shelves full of books. And I went through it and ended up finding enough. And then over the years, I taught the course. My students did papers, the typical paper involved finding some legal system and doing what I'm doing in my chapters for that legal system. So I learned more from that stuff. And then I ended up putting it together into a book. But it really was a way of making myself do something that I thought I ought to do, to announce this seminar before I really had the information to teach it.
You could almost write a whole behavioral economics paper about hyperbolic discounting and commitment devices, evidence from David Friedman's career.
Yes, because it's not limited to this book.
Mm-hmm.
I've written at least one other book, and probably more than one other book, where my final commitment mechanism was that the book was the text for a course I was teaching. This is a book that hadn't been finished or published yet, typically a book where I had it more or less in draft. And so I had to get each chapter into a form I was willing to give my students by the week when that chapter was due on the syllabus. So that was the same basic commitment mechanism, but on a somewhat smaller scale. So I'm pretty sure that's how I did Law's Order. And I'd have to go back. It's been a while as to whether there are other books where I used that approach, but it works pretty well.
So since you mentioned the private prosecutors in 18th century Britain, we should probably talk about exactly how that happened. It seems like there would be a public goods problem here. How did the prosecutors earn a living doing that?
Yes. Basically, what first got me interested in 18th century England had nothing to do with it. And that was that there was an old article by Gary Becker, who was really more or less the first person doing economics of crime work, where he argued that it looked as though the optimal system of punishment was basically the highest possible punishment and adjust down the probability of imposing it in order to get the expected punishment, the probability times punishment you wanted. And he then had some explanation of why that didn't happen, which I think was wrong. That's another issue. But in any case, the reputation of 18th century England is it's what's called the Bloody Code, because essentially all serious offenses were capital. And so that's when I first got interested in it. But it turned out first that it wasn't really true, that on paper all serious offenses, manslaughter really wasn't, but almost all serious offenses were treated as capital. But if you actually looked at the numbers, if you were charged with a capital offense, your chance of hanging was something like, 1 in 8 or so. And if you were convicted of a capital offense, your chance of hanging was still less than even. So that it was a system that was capital on paper, but with various other things. But then I got interested in the fact that it was a system in which prosecution was private, usually by the victim or his agent. That's true of our tort system, of course. But the difference is that with the tort system, when you win a tort case, the other guy owes you damages. In the English system, if you win a criminal case, either they hang the guy, or maybe they pardon him, or maybe they pardon him conditioned on his agreeing to enlist in the Army or the Navy if they have a war on, or maybe they pardon him conditioned on his agreeing to be transported to the New World for, 18 years of indentured servitude as a basically temporary slave, but you don't get anything out of it. And so the question was, why does anybody prosecute? Why does anybody bother? And I think there are at least 3 different reasons. For some offenses, some of the time there were rewards. The Crown would establish a reward for convicting particular people of particular kinds of offenses. Second, you want the reputation that if somebody robs you, they will hang, so people won't rob you. And if you're a repeat player, if you're, say, the kind of store which is at risk from shoplifters, it would be worth prosecuting one who you catch in order to get that reputation. And you see that today, that you'll see a department store that has a sign saying we prosecute shoplifters. And it isn't literally true, because in our criminal system, prosecution is by the state. What they really mean is that we'll go to a good deal of trouble to get the government to prosecute shoplifters. But in the English system, it was up to you. And you could see that if you're a repeat player, you have an incentive. But the problem is, if you're an ordinary individual, you might be the victim of a theft, every 5 or 10 years. That's not enough to establish a reputation. It's going to cost you time and energy, effort and money to track down the thief and get him convicted. Why do you bother? And they had a very ingenious solution to that, which was what they referred to as a society for the prosecution of felons. So you've got a bunch of people in one town, typically, who agree to each chip in an annual fee to a pool of money, which will be used to pay the cost of prosecuting anybody who commits a felony against any of them. And the final step is that the list of the members of the association is published in the newspaper for the felons to read. So it looks like insurance, but it's really, I argue, a system of pre-commitment. That by joining the association, you have announced, if you commit a felony against me, you're quite likely to get prosecuted and convicted because I've already paid my dues, the money is there, and therefore people are deterred from doing it. So it's a way of converting deterrence from a public good into a private good. And we have versions of that today that, you may, I seem to remember the American Automobile Association, I don't know if it still does. At least at some point it had a sticker you put on your car, which essentially said, there's a reward for catching the person who steals this car from the AAA. And you've got various other private mechanisms, which essentially are warning people, I've borne some costs, which will make it more likely you will get caught and punished if you commit a crime against me. But the third reason, so one reason was for rewards. One reason was private deterrence. And the third reason was in order to settle out of court and get paid. So that if you've committed a felony against me, I make it clear that I can convict you. And I then offer to, in effect, drop the case if you'll pay me off. And that was illegal. That was the original meaning of compounding a felony, it turns out. But in fact, I think there's good evidence that it happened pretty commonly. So that was another reason why you might prosecute. And of course, there's always the fourth reason, which is that people feel vengeful. That, this guy stole my horse, I'm mad at him, and so I'm willing to go to a lot of trouble to get him convicted. But I guess that one sort of goes without saying. But in any case, the system seems to have worked tolerably well. One of the interesting issues you get in it is that people are worried that there's not enough incentive, and so they argue for putting in more rewards. And the trouble is that once you have generous rewards for catching people, there's an incentive to catch and convict people who aren't guilty, or else to entrap people, to basically set up crimes where one of the guys organizing the crime is the one who plans to turn in the others and collect the reward. And there were some notable scandals along those lines in the mid-18th century, which resulted in scaling back the system of rewards.
So it's interesting that essentially settling out of court was illegal but widely practiced, because you pointed out as one of the positives of the system, one of the ways the things that made it work quite well and be somewhat efficient from an economic standpoint. One thing in a lot of legal systems, in a lot of legal traditions, they often trace their origins back to some historical or mythical lawgiver who there's almost a theory that an implicit theory that this law system was designed by some wise person in the past. But I think one thing you get from reading your book is that these systems tend to evolve in ways that benefit the people in them. Could you talk about that a little?
It's an interesting question. Certainly, I guess in a sense, one of the strongest, clearest cases are the ones which are the religious legal systems, the Jewish and Islamic, because there you start out with rules which people don't like, and they then find ways of interpreting around them. My standard example for Jewish law is the disobedient son. That what Torah says is that if you have a disobedient son, you're supposed to stone him to death. You're supposed to bring him to the city authorities who will have him stoned to death. And you then have all of these commentaries by legal scholars, of whom the one I'm most familiar with is Maimonides, who I think is very good, who basically find ways of claiming from the wording of the text that there are a whole bunch of conditions that have to be met before you can actually stone a disobedient son. And the conditions are, according to many of the sources, I think including Maimonides, the conditions are so severe that it never happens, literally never happens. And the case for Islamic law that is in some sense related to this is the legal rule that people are always horrified by about cutting off the right hand of a thief. And that's in the part of Islamic law, what's called had offenses, which claims to be based on the Quran, although parts of it really aren't, but at least based on very early sources, and where the legal position is this is God's law and men can't change it. And that's one of them, but then it's interpreted in such a way that in order to qualify to have your hand cut off, you've again got to meet a whole bunch of conditions. That you can't do it for stealing food, for example. It is assumed that if you stole food, it was because you're starving, and a starving man stealing food does not count as the had offense of theft. You can't do it if the property was not protected. If you steal cattle grazing in the field, that's not the had offense of theft. If you steal from a house where you're a guest, it's not the had offense of theft because the property wasn't stolen from you. It's got to be more than a certain amount to count. If you have any grounds for believing the property is yours, even if you're wrong, it isn't the had offense. So that some scholars, I think, held that stealing from a sort of the equivalent of the government treasury couldn't qualify as the had offense of theft because you might say, well, as one member of the Islamic society, this is partly my money. So there are lots of interesting things. One of the other interesting things I should say in Islamic law that I thought was quite neat, this isn't really a response to your question about changing, is that the tax system is one in which you are religiously obliged to pay taxes, but you don't have to pay them to the government. That the taxes, the religious tax, is supposed to go to a list of purposes, such as taking care of travelers, helping the poor, helping people who are fighting for Islam. I don't remember the list, but I think there are about 8 different categories. You can, if you like, calculate the amount you owe and hand it over to the local ruler to distribute. You can also just pay it out yourself to these categories, like into independent charity, or you can agree with a middleman, private middleman, who in exchange for getting, I think, 1/9 of the money himself to pay him, will then distribute it to the appropriate recipient. So I thought it was sort of an intriguing idea as a different approach to taxation. But in all of these things, you certainly see things change over time, sometimes for the better, not always for the better, as people adapt their behavior to how the system works.
We're nearly out of time, so I want to ask. I want to tie it back to our current.
I hope
system.
You will tell people where the book draft is so they can read it.
Oh yes. So daviddfriedman.com.
My webpage is www.daviddfriedman.com, and that's Friedman, Friedman. And if you go to that webpage, a ways down it, I have my books, and there is a link to the current draft of that book there, as well as links to a variety of my other books. I basically give information away when I can because I'm writing books mainly to spread ideas, not mainly as an income source.
Yeah, I'll also link to it from economicsdetective.com where we have the show notes page for this episode. I wanted to, returning to the conversation though, I wanted to ask, let's say someone was writing a book like this, say 500 years in the future, and they were looking back at the American legal system of 2017. What would you say is is really unique in this system? Is there anything that's, if not completely unique, particularly notable that that people would notice?
One very notable feature, which some people would argue is a fault, not an asset, is the system of plea bargaining. That we have this elaborate procedure for courts, for criminal trials, in which theoretically you don't get convicted until it's been proved beyond a reasonable doubt that you're guilty, but almost nobody actually gets that. That, something, I don't know what the numbers are, but something like 95 or 98% of all cases are settled by plea bargaining. And you do not, in fact, have to be anything like guilty beyond a reasonable doubt to end up getting convicted. Because if the prosecutor says, we think we might be able to convict you of a crime that will put you in prison for 20 years, but if you're willing to plead guilty to a much lesser related offense, which will put you in prison for 1 year, we're willing to make a deal, you may well plead guilty to that 1-year offense, even though you're perfectly innocent, because you believe there's a significant chance that you could get convicted of the more serious offense. So the fact that we have such a system is sort of one of the very interesting features of our system. And there's a article that I quote a little bit in the book by somebody who is actually looking at the medieval law of torture and arguing that the medieval law of torture and our system of plea bargaining really come out of the same problem, that you have standards of proof that are so high in the attempt not to convict innocent people that you can't, in fact, convict guilty people. And you're not willing to do that, so you find some kludge, some way of working around it, where in the medieval law of torture, the way of working around it is you torture somebody, then he confesses. If he confessed under torture, it wouldn't count because the confession has to be voluntary. That's all right. You stop torturing him, then ask him if he wants to confess, and if he doesn't confess, you torture him again. And that's a crazy system. And he argues that our equivalent of that is that if we really gave everybody a trial, it would take enormous amounts of resources. I have a calculation on how many people it would take working full time if we really settled everything by a real jury trial. So we have this plea bargaining system where we don't torture them. We just say, there's a risk that we can put you in prison for 20 years. How would you like to deal? And we thus claim to have a system which will only convict guilty people, but don't actually have such a system, in the process of working around the fact that we went too far in trying to make it only guilty people. So that's certainly one of the more interesting features of modern American law. But there are a fair number of ways in which the modern system reflects some of our problems. So that, for example, one of the issues I discussed with the English system was when rewards meant that it was worth convicting people whether or not they were guilty. Similarly, our system of civil forfeiture means that it is worth seizing people's property who have committed no crime, who you don't really believe have committed a crime, but where the cost to them of going through the legal procedure in order to get the property back is high enough so that the police end up holding the property. And that seems to be a fairly common abuse of our present system. And I'm sure there are other features, but those are some of the ones that I find interesting.
Your final chapter is Ideas We Can Use, and I think that's a good place to conclude the conversation. What's the best idea, in your opinion, that we could incorporate into our modern legal system?
I don't know about the best. The simple one, which I mentioned before, is the idea of making tort claims marketable. But there are a variety of other things. I think there's much to be said for the feud law approach, and that, in fact, it really exists in our society implicitly in a variety of contexts that I discuss. The Athenian legal system had a rather neat system for self-revealing, basically a way in which it was in your interest to admit how rich you were, which was relevant because the richest people had to do certain things. It was sort of like a tax in kind for producing public goods. And the basic deal there was that if somebody said, you're one of the richest people, you have to sponsor our team at the Olympics, I could say, well, look, that guy over there is richer than I am. He's not doing anything this year. He didn't do anything last year, and you're supposed to do one of these things every other year, so we should do it instead. And if he denies that he's richer than me, my response is, all right, I offer to trade everything I own for everything you own. If you turn me down, you've admitted you're richer than I am. And variants of that approach of making it in people's self-interest to admit something, I thought could be used, probably are used. Claiming horse races actually work on the equivalent of that principle, if you're familiar with those. I think I discussed them briefly. But if you really want my full list of ideas we can steal, read the book. You can read it for free on my webpage.
And on that note, we'll end the conversation. David Friedman, thanks for being part of Economics Detective Radio.
Thank you.
As I mentioned during the episode, you can find a link to David's book, The Latest Draft, which you can read online for free at economicsdetective.com/legal. If you enjoyed this episode, if this is your first time listening, I encourage you to subscribe to the podcast through your favorite podcast app. Just search Economics Detective Radio or just Economics Detective and hit subscribe. You won't regret it. I have great guests like this one every week. and we have a lot of interesting discussions related to law and economics and history, and I'm sure you'll find something in it you enjoy. Special thanks to my supporters on Patreon who helped create this episode by supporting it monetarily. If you want to become a supporter, you can go to economicsdetective.com/support. Thank you, and I'll be back next week.